Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the new SEC guidance on cybersecurity disclosures. On February 20th, 2018, the SEC issued new interpretive guidance on public company disclosures related to cybersecurity risks and incidents. In addition to addressing public company disclosures, the new guidance reminds companies of the importance of maintaining disclosure controls and procedures to address cyber risks and incidents, and also reminds insiders that trading while having non-public information related to cyber matters could violate the federal insider trading laws. Public companies have many disclosure requirements, including through periodic reports on Forms 10K, 10Q, and 8K, through Securities Act registration statements, such as on Forms S1 and S3, and generally through the anti-fraud provisions of both the Exchange Act and the Securities Act, which require a company to disclose such further material information, if any, as may be necessary to make the required statements in light of the circumstances under which they are made not misleading. The SEC considers omitted information to be material if there is a substantial likelihood that a reasonable investor would consider the information important in making an investment decision, or that disclosure of the omitted information would have been viewed by the reasonable investor as having significantly altered the total mix of information that is available. As with all disclosure requirements, the disclosure of cybersecurity risks and incidents requires a materiality analysis. Although there continues to be no specific disclosure requirement or rule under either Regulation SK or SX that addresses cybersecurity risks, attacks, or other incidents, many of the disclosure rules encompass these disclosures indirectly, such as risk factors, internal control assessments, management discussion and analysis, legal proceeding, disclosure controls and procedures, corporate governance, and financial statements. As with all other disclosure requirements, an obligation to disclose cybersecurity risks, attacks, or other incidents may be triggered to make other required disclosures not misleading considering the circumstances. A company has two levels of cybersecurity disclosure to consider. The first is its controls and procedures and corporate governance to both address cybersecurity matters themselves and to address the timely and thorough reporting of same. The second is the reporting of actual incidents. In determining the materiality of a particular cybersecurity incident, a company should consider the importance of any compromised information, the impact of an incident on company operations, the nature, extent, and potential magnitude of the event, and the range of harm such incident can cause, including to reputation, financial performance, customer and vendor relationships, litigation, or regulatory investigations. Of course, the new guidance is also clear that a company would not need to disclose the depth of information that could, in and of itself, provide information necessary to breach cyber defenses. A company would not need to disclose specific technical information about cybersecurity systems, related networks, or devices, or specific devices and networks that may be more susceptible to attack due to weaker systems. The new guidance also reminds companies that they have a duty to correct prior disclosures that the company determines were untrue at the time made or that material information was omitted, and to update disclosures that become inaccurate after the fact. Like the prior guidance, the new guidance provides specific input into areas of disclosure, which I will begin to discuss in the next LawCast in this series. I'm Securities Attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.